Please be seated. First up is 1424-00639 Endeavor Natural Gas versus Comanche Maverick Ranch Investments. Appellant present.
Yes, Stephen Barrett for the appellant, Endeavor.
All right, you ready, sir?
I am.
Do you want to reserve some time for rebuttal?
Yes, 5 minutes.
All right, Appley, are you ready?
Yes, Your Honor.
All right, let's begin.
May it please the court. The Texas Supreme Court has long recognized what it calls a strong public policy favoring the exploration and production of natural resources, including oil and gas, as well as disfavoring anything that hinders that strong public policy. And this is a case that intersects with that policy. The appellee, Comanche Maverick Ranch, which I'll refer to simply as Comanche, signed an oil and gas lease granting Endeavor the exclusive right to explore for oil and gas on its property in Maverick County, down on South Texas along the Mexico border. That includes the right to use the surface estate in connection with those oil and gas operations. Now, it's undisputed, and it's been the law in Texas since at least the 1950s, that the right to explore for gas and oil includes the right to conduct seismic testing on the property, even over the landowner's objection, subject to the lessee's obligations as a lessee. So there's no question that that right exists. The issue in this case is whether a surface use agreement that the parties entered into in connection with this oil and gas lease takes that right away. The district court...
Do you have a right to do it without a permit?
Yes, under Texas law, the exclusive right to explore for gas and oil includes that right to conduct seismic operations on the property in connection with that.
Without a permit, you just
even without the permit. This permit idea only comes in under the surface use agreement. Mm-hmm. So the question is whether this surface use agreement took that right away.
What is your authority for that position, that it doesn't require a permit? You could have done it without a permit. What's your authority for that position?
There's a long line of authority in Texas, but I'll say Yates versus Gulf Oil, a Fifth Circuit case from 1950, and there's other cases as well that follow that. But that goes in. If you look at Williams and Myers and any oil and gas treatise, the right to conduct seismic operations is part of the right to explore for gas and oil on the property.
And were y'all, before the failure of this clause, before y'all didn't reach a permit, were there geophysical operations being conducted?
My understanding is that there had not previously been geotechnical operations on this particular property.
But the leases were still being developed. There was oil and gas.
They were being developed
without the geophysical operations.
They had not yet reached the point where they decided they needed to do geotechnical. That's right.
Even if we agree with you that the authority allows you to conduct this type of activity without a permit, we have the surface use agreement that does contain a provision to allow for those types of activities, do we not?
Yeah, that's absolutely correct. The whole issue in this case is whether that surface use agreement operates to prevent us from being able to exercise that right.
I mean, if it's in the contract prevails. Is that correct?
Well, subject to what the contract says in Texas law on how you interpret and apply those contracts, yes.
Okay.
So the district court essentially interpreted section 7.0L of the surface use agreement, the operative term of this agreement in this case, as a consent provision, as if what the contract actually said was that seismic testing shall not be allowed without first obtaining the express written consent of the landowner, which may be unreasonably withheld. That's how they've effectively interpreted this. That's always been Comanche's position, is that we will not consent to this, therefore we will not enter into a seismic surface use agreement, therefore the condition has failed and therefore you can't conduct seismic operations.
What efforts did Endeavor make to obtain the permit to conduct the seismic activities on the surface before litigation ensued?
First they went to Comanche, told them they needed to do seismic and we need to enter into this agreement. They ignored that. And then council got involved and raised the same point again, and they said, we don't have to enter into any agreement, but if you want to send one over, we'll look at it. They never commented on that. They simply said, we will not agree to this.
So your position is that Comanche did not have the right to unilaterally withhold agreement to a permit?
That is
So
our position on that.
how much did they have to do? Because they didn't have to agree to a permit, right? Because it says mutually agreed upon seismic surface use permit.
Well, that's part of the problem with this provision, is it's an agreement to agree. It requires a mutual agreement to terms that haven't been decided yet. And it's impossible to enforce that because there are no terms that you can say are reasonable or they're required or not required. The way this is written, our client could take the position that the terms are nothing other than we got to do this during daylight hours. They could take the position that you can only do this if you pay us $10 million a day. There's no terms that are for this seismic surface use permit that are provided, and that's one of the big problems with this case. This is a classic agreement to agree that lacks all of the essential terms of it and can't be enforced.
What if
Now,
we disagree with you and find that it's a valid condition precedent, then what?
if it's a valid condition precedent, then it's excused as a matter of law. Texas law is well settled that if a contractual right is subject to a condition precedent and the other contracting party prevented that condition precedent, then the condition precedent is excused or is deemed to have been fulfilled.
So this is really more my question. So say we hold that it's a valid condition precedent, and you're saying they could not unilaterally withhold. So you're saying they just did not engage at all on reaching a permit, and that means it was deemed fulfilled. How many steps did they have to take to reach a permit with Endeavor? Did they have to negotiate? Did they have to negotiate in good faith? What? Do you see what I'm saying? Like, say they don't reach a permit.
There's a line that you're trying
Yeah.
to look for. Where is the line? And that's unclear. The law doesn't clearly state that. But in this case, it's very clearly on the side of excuse because they wouldn't engage at all. Their position was,
But they
we are
did.
not giving you a permit, and therefore we're not going to negotiate one of these agreements with you.
But they did engage. You said that council got involved. I read somewhere that Comanche's position is that there was a type of form that was required. Did Endeavor ever hear as to how Comanche expected Endeavor to approach obtaining this particular permit under that specific provision? Or was it unclear to Endeavor? I mean, do you understand my question?
The record shows that counsel for Comanche told the trial judge point blank, we will not agree to this, period. No, that's not conditional, it's not subject to certain terms, it's not that we found that your agreement was unreasonable, it is we will not agree to this.
Where is that in the record?
It is in the Reporter's Record, Volume 1, pages 48 and 50.
And why is it, is it your position that Comanche, first of all, cannot take that position, specifically to this provision? And if that is your position, why can they not take that position?
They can't take that position because the law is that if you have prevented the condition precedent from being met, the condition is deemed to have been satisfied. And that's what happened here. Comanche unquestionably refused to enter into any negotiations for a seismic surface use permit. That's why the condition precedent of entering into a seismic surface use permit failed, and that's why we aren't able to exercise our right to conduct seismic operations.
So one phrase that's giving me a hang up here is the mutually agreed upon, because it seems to me like your argument could just take that out. So it would then say only after first entering into a seismic surface use permit. And as you know, we can't read you know, we can't read words out of out of a contract. So I'm just wondering what you do with the mutually agreed upon language.
Well, I think the mutually agreed upon language is the reason why this is an unenforceable agreement to agree. How do you enforce an obligation to reach a mutual agreement when you don't have any terms to agree upon? That's the problem with Section 7L, is it requires the parties to enter into a future agreement that is entirely open to future negotiations.
But Endeavor, in fact, entered into this contract with that particular provision with Comanche, did it not?
Well, it was willing to negotiate an agreement. It expected that the landowner was going to be reasonable and agreed to something reasonable. Here they simply took the position that this is effectively a consent provision and we're not going to consent. And the parties knew how to write a consent provision. This surface use agreement has at least 7 consent provisions that all say you can't do a certain activity unless you first obtain the landowner's prior written consent, and then sometimes they say whether that consent can be withheld. Section 7.0L doesn't have that language in it. What it does say is that we have a right to conduct seismic activity, and that before you do that, exercise that right, you have to enter into this mutually agreed upon seismic surface use agreement, which like you said, they call it a permit. That's not a consent provision. That is a right that's subject to a condition precedent, which is it's either an unenforceable agreement to agree, or it's excused as a matter of law. So I see my time is up. If the court doesn't have any other questions, I'll wait until rebuttal.
Thank you, sir.
Good afternoon, and may it please the court. My name is Mia Lorick, and I represent Appalee, who I will refer to as CMRI. CMRI respectfully requests that this court affirm the judgment of the trial court for 2 reasons. The first reason is that the trial court did not err in granting CMRI's motion for summary judgment because 7.0L is a condition precedent that has not been met, which Endeavor concedes. My second point is that the trial court did not err in denying Endeavor's motion for summary judgment because 7.0L is not an unenforceable agreement to agree. As this court knows, the standard of review after a trial court's ruling on competing motions for summary judgment is de novo. To my first point, counsel got up and talked about the long-standing common law in Texas, but here we have operative agreements that govern the conduct of the parties and this court's analysis. Now, you heard about the surface use agreement. The surface use agreement was executed on the same day as the lease. Texas law tells us that 2 agreements interpreted on the same day for the same purpose shall be read together. To understand provision 7.0L, you have to first look at the lease and how the lease references the surface use agreement. The lease, section 3A, found at Clerk's Record 483, states that all operations on the leased premises shall be subject to the terms and conditions of the surface use agreement. It goes on in section 21 to state that any seismic activity after the date of this lease shall be conducted pursuant to the terms of the surface use agreement.
So do you agree that Texas law gives them the right to do geophysical operations? And then you're saying that this carves it out.
That's right, Your Honor. Texas common law does provide a right to explore and develop the property, and historically that does include seismic operations. The reason that the surface use agreement was entered into was because the parties wanted to alter that common law right and put conditions on that right.
And what are those conditions? Because I don't see any way as to how Endeavor would understand that they've met the condition precedent in order for you to give them the permit that they're requiring.
Yes, if the parties choose to mutually agree on a permit, then Endeavor can conduct seismic operations. Now, the surface use agreement speaks to the purpose of the agreement.
Counsel, I'm sorry, but I keep coming back to this. You seem to be nodding your head differently when you're over there while your opposing counsel was up here, saying that your client was never going to agree to this permit. is that your understanding of the situation?
That is not my understanding, Your Honor. My first point on that is I do not believe the reporter's record, Volume 1, is a part of the summary judgment record. That's kind of the first procedural issue with that. I do believe that testimony is taken out of context, and that testimony was related to the specific proposal that Endeavor submitted before this lawsuit was filed. Now, Justice Onto, you asked how many times did Endeavor submit or try to agree? Once. Endeavor reached out one time and said, we would like to conduct seismic operations. CMRI said, okay, send us your proposal. The proposal that Endeavor sent was wholly inconsistent with the surface use agreement, which says that we want to preserve the wildlife, prevent soil erosion, prevent damaging of trees, prevent harming and hurting the animals on the property. And so CMRI said, we're not going to agree to this. Endeavor then took the position and said, well, we're going to enter the property on July 8th, 2024, and we're going to conduct seismic anyway. They didn't come back with another proposal. They didn't say, we've altered terms 3 through 6, can you take a look at this? That's what the parties should have engaged in.
Is that a remand point if we get to that step in the analysis?
No, Your Honor, because what the trial court found is that it's a condition precedent that simply has not been met. It means that the provision is still in effect and that the parties are still operating under the operative contracts, and that as they continue to operate under the lease and the surface use agreement, there may come a time where they mutually agree.
So
Go ahead.
is your position that y'all could unilaterally withhold consent for any reason?
We can unilaterally withhold entering into a conditional permit the same way that we cannot force Endeavor to conduct seismic in a certain way. Counsel said, well, then you may say you can conduct seismic, but it's $10 million a day. The contract says if the parties mutually agree. Endeavor doesn't have to agree to that.
So then what about all the other consent provisions?
The consent provisions give CMRI the right to say yes or no, and that's it. There's no discussion. When you're considering a situation where the parties are saying we may choose to mutually agree, to me that opens up a discussion.
So you're not saying, and I think I misinterpreted your position in the briefs, and I want to make sure I'm clear as to what your position is. Justice Boatman asked you about the 7 other provisions that Endeavor brought up that specifically include language that allows CMRI to not consent if you don't want to. Are you telling me that this provision, well, I know that this provision does not contain that specific language, but your position is we haven't reached a mutually agreeable position in order for us to grant them the permit. It's not that you're withholding all consent, as the other 7 provisions allow CMRI to do.
That is correct.
And so if that's your position, is Endeavor just supposed to submit thousands of proposals until CMRI sees fit that the proposal they've sent is, in your position, compliant with the rest of the surface use agreement? I mean, that could take months or years. If CMRI's position is that, then you could just continue to move the ball and never grant them a permit at all.
I understand, Your Honor. I don't think there's anything in the record to suggest that CMRI would make Endeavor submit thousands of proposals. In fact, CMRI is the party that asked Endeavor to submit a proposal. Endeavor came and said, we want to conduct seismic, and CMRI is the one that said, show us what you intend to do so we can consider it. Endeavor stopped the discussions there. I don't know whether or not the parties would have reached a mutually agreeable permit had they continued those discussions. We don't know.
If that is the case, then I'm going to piggyback on Justice Boatman's question. Is the record developed enough at the trial court below for us to make the determination that, because I thought that CMRI's position at the trial court below was we can withhold consent if we want to, but you're telling this court that's not your position. So shouldn't we remand this case in order to build the record on whether or not Endeavor has submitted a proposal that should be mutually agreed upon by CMRI?
No, Your Honor, and that is because the issues before the court were whether or not this provision should be interpreted as a condition precedent or an unenforceable agreement to agree, meaning Endeavor wants you to strike the provision completely. And so a remand is not appropriate in this scenario because you're interpreting these contracts as a matter of law. If it's a condition precedent, then Endeavor concedes that the condition has not been met. Endeavor says that even though it's drilling, it hasn't conducted seismic and it doesn't have a permit to do so.
But is it not relevant whether or not you've decided not to negotiate in any way with Endeavor to give that permit?
I don't think that that is relevant for this court's analysis because I don't think that there's been an argument or allegation of any sort of impossibility. Now, Endeavor does say that we are preventing the condition from being met and therefore the condition is excused. But in the cases that Endeavor relies on in the situations where courts excuse the condition, the party is preventing the other party from exercising a right or an obligation under the contract. For example, there's a case where there was an obligation to drill a well and the other party filed a lawsuit to stop the drilling. In that scenario, the obligation to drill was excused and not considered a breach.
So, I'm not sure I'm following that argument because in those cases it's a condition precedent, right? So it's not a real it's not like a just obligation, an absolute obligation under the contract, right?
Well, in the cases that Endeavor cites, there is a condition precedent that the other party is saying, because you prohibited me from doing this, I get to exercise my right anyway. But in one of the cases that Endeavor cites, the court didn't find excuse. The court said that if you find a condition precedent, the condition has to be met. The same is true here. The language only after, as our sister court tells us in Tabe, creates a condition precedent. Only after the parties enter into a mutually agreeable seismic use permit does Endeavor get the right to conduct seismic. This is negotiated language.
But if you refuse to engage in any type of dialogue that would allow them to submit a proposal that is to your liking, then let's say we agree with you that it is a valid condition precedent, okay? If Endeavor's position is that CMRI is not engaging at all, then how is Endeavor ever supposed to reach a mutually agreed upon agreement in order for you to issue that permit? I mean, that's impossible. That could never happen. So it can't be that CMRI just refuses to engage at all and says, well, the condition has not been met, we're entitled to declaratory judgment on this. I mean, that can't be.
Well, CMRI is not taking the position that it won't ever agree. Again, there was only one proposal that was submitted.
But isn't that something, based on the limited record we have here, something that should be dealt with at a trial court level so we can have a full record to make that determination?
You do have a full record. You have what was before the trial court, and attached to the motions for summary judgment are the parties' correspondence on the issue. The parties cut off the discussions on the permit when Endeavor sent its letter stating that it was going to enter the property and conduct seismic anyway.
Finish your thought and then.
That's the record before the trial court, and on that record, the trial court then concluded that this provision is a condition precedent that wasn't met. Endeavor could have come back and said, look at this proposal, we made some changes, can we have further discussion?
Since we're talking about the record, you mentioned that reporter's record 48 through 50 was not in the summary judgment papers. Can you expound on that argument?
Yes, Your Honor. The reporter's record volume 1 is the transcript from the temporary injunction hearing. The temporary injunction was denied by Judge Bo Miller. The temporary injunction denial is not at issue on appeal. Endeavor is only filing an appeal as to the motions for summary judgment.
So if Endeavor had not sent the message, well, we're going in anyway, and this litigation would not have ensued, perhaps we wouldn't be in the position that we're in. Is that what I'm hearing?
That is likely, but I can't predict what would have happened, but that is likely. But
Okay.
the litigation was initiated based off of Endeavor saying, on this date, we're entering the property and we're conducting seismic operations in accordance with what we said we were going to do, even though there's no mutual agreement. And that's what sparked the litigation and the interpretation of this provision. I do want to point out the Texas Supreme Court case, Fisher versus CTMI, from 2016. In Fisher, Justice Boyd authored the opinion and makes the point that it is universally recognized that if there are two constructions, one of which is valid and one is invalid, that the court should go with the valid position, that the court should shy against forfeiture. And so taking Endeavor's argument and taking that it's an agreement to agree, they are trying to insert that there's a requirement that the parties mutually agree. Now, the mutual agreement is a condition precedent, but the language doesn't say that the parties will mutually agree. It doesn't step into the realm of an unenforceable agreement to agree because it doesn't require an agreement that then has uncertain terms. And so that's the distinction I want to make here, because in a lot of the briefing, there are paraphrases and it's murky, and the language is very clear in our contract, and the Texas Supreme Court cautions against altering that language or inserting words.
So if it is an unenforceable agreement to agree, there's no severance provision, so would that put into jeopardy the entire surface use agreement or just this provision? I know this is not your argument, so it's hard to, I really
But to answer your question, Justice Boatman, if that were the case, then I think Texas common law would say that you would strike the entire provision. Now, I will tell you what Endeavor wants is for you to redline the provision, that you would take out the mutually agreed upon permit and give them the right to conduct seismic, but you would strike the provision that actually grants them the right to conduct seismic once the condition is met. If there are no further questions, I will yield the rest of my time. Thank you.
Thank you.
Couple of things. First, I would urge the court to look at the letter campaign that happened right before this lawsuit was filed. I think that the version of the facts that counsel just recited is a little inaccurate. There are 4 letters. They're clerk's record 226, 229, 232, and 235. And I think that you'll find that they very clearly show that, yes, there was an initial request for us to send them a proposed permit. There was absolutely no effort on the other side to negotiate that at all. Their position rather...
Sounds like their position was they didn't agree with your proposal, so why not submit a second or a third or however many it takes in order for you to have a mutually agreed upon agreement to get the permit that you so required.
I think Your Honor's point is good, that you'd have to be doing that over and over and over again. You don't even know what their objection to your written proposal is. Their position was, we're not going to agree to this at all. And the reason why there was this, the statement that we're going to go and do this anyway is because Comanche's lawyer took the position that, well, this agreement is an unenforceable agreement to agree. And so you can't enforce it. And so we said, we agree with you. We have a right at common law as the dominant estate to go in and do seismic. And the response was not that we need to keep negotiating this deal. You need to change this, this, and this. No, there was none of that. It was like, no, you can't do seismic, and we're going to sue you to stop it. So I think the facts are very unambiguous here, that Comanche would never agree, not just to the permit that we proposed in response to their initial request, but they won't agree to any proposal because they didn't want seismic on their land at all. They wanted to treat this provision as a consent provision where they have unlimited discretion to withhold that consent. Now, there were a couple of other points I wanted to address. One was, counsel argued that the rule that interference or prevention of the condition only applies to absolute contractual obligations. There are at least 2 of the cases that we cited that didn't even involve that. The Donaldson case was a stock option that had the condition precedent was that you send a written notice of your intent to exercise it. Neither one of those things were mandatory. The court applied that doctrine to that scenario in that case. It didn't find it was prevented, but that was because the facts in that case were that the other side hadn't prevented it. Here, we have undisputed facts, I think, if you look at the record, that they prevented it and they were never going to let us do seismic on this property under this agreement.
What evidence is there in the record to support your position that they were never going to let you conduct seismic operations? Because if I'm CMRI and the law allows you to conduct those seismic activities anyway, except I put a provision in the surface use agreement that allows me to control in which way, right? That doesn't sound like they're never going to let you do it. They just didn't agree to the proposal that you submitted. So what evidence is there in the record to suggest that they were never going to agree to any proposal that you submitted?
Well, there is the statements on the record directly to the judge saying that point blank.
So how do you respond to the argument that that was during the temporary injunction?
Well, it was the same judge, and their position never changed, and it's consistent with their letter writing campaign that I mentioned before, where they took the position after we sent them a proposal that, no, we don't have to agree to this. We're not going to let you.
So you agree that generally we wouldn't be able to consider testimony during the temporary injunction hearing in reviewing the summary judgment?
I agree that. I'm
That
sorry.
we generally should not consider evidence that was admitted at the temporary injunction hearing.
Well, it was evidence in the record that was fully consistent with everything that was argued in connection with the summary judgment. Whether that particular part of the reporter's record was part of the summary judgment evidence, that's less than clear. But it's completely consistent with the position that they took during the summary judgment, in their briefing, in the letters that they wrote before the hearing, and their argument was, it wasn't that this is an unacceptable agreement that you're proposing for the permit. It's that we don't have to agree to this. We're not going to agree to it. Your condition failed. You can't do seismic on this property.
So if we agree with you that it's an unenforceable agreement to agree, do we excise the one provision, or does it put the whole surface use agreement in question?
It's just the one provision. If you look at cases like the Fort Worth ISD case, they didn't throw out the whole agreement, or the Ski River, they didn't throw out the whole agreement. They threw out the provision that has an unenforceable agreement to agree. And plus, under the law, if an agreement isn't essential to the purpose of the contract as a whole, it is severable, whether you have a severance clause in the agreement or not. And this is just one small piece of a much larger agreement. The central purpose of it isn't seismic. It's just to generally lay out the ground rules for using the surface. So it's a severable provision, and since it's unenforceable, it should be. If there are no other questions, request that the judgment be reversed and rendered, except for our counterclaim for breach of contract, and that should be remanded for further proceedings.
All right. Thank you, sir. This case is submitted. All right, gentlemen, are y'all ready? Next is 1424-00618 CV, Darla Holloway individually and as next friend of DHKK and AH Minors, and Tangelo Fields as next friend of DI Minor, and Kenneth Holloway versus Harris County, Texas. Appellant, ready?
Yes, Your Honor.
You want to reserve some time for rebuttal?
3 minutes, Your Honor.
3 minutes, thank you. Appellee, are you ready?
Yes, sir.
All right, you're coming the right direction. Let's get started.
Good afternoon. I'm David Chapin, and may it please the court. In this case, Deputy Sharina Mason is not entitled to official immunity. She failed to conduct an ongoing assessment of the circumstances involved in the particular pursuit of the suspect in this case. She failed to engage her overhead lights and her siren when Harris County Sheriff's Department policy called for it, when Texas Transportation Code section 545.003 requires it, and the ongoing assessment of the risk need factors was absent in this case.
So what difference would the sirens have made here?
Well,
Sirens and overhead lights.
yes. Well, Your Honor, this was an active intersection. And when Deputy Mason arrived, she was facing two vehicles that had their lights on, one of which was the plaintiff. And there were people on both sides of the street, as she admits to. People are spilling into the street, telling her that the suspect was the fleeing vehicle. And by executing the three-point turn, the first turn, everything was in front of her, so she could see everything. But when you're reversing your vehicle, as she admits, there was about a 3-second stop before she began backing up. And the vehicle that was next to the curb, that was in front of her, that she could see the whole time with its lights on, it left confusion. And it allowed for some indecision on the part of that person as to what exactly she was going to do and whether she could proceed. And if I may, Your Honor, under Texas Transportation Code section 545.156, which is entitled Vehicle Approached by Authorized Emergency Vehicle, it names various types of emergency vehicles, one of which is a police vehicle lawfully using only an audible or visual signal. If that's what you are approached by, then the person must, 1, yield the right-of-way, 2, immediately drive to a position parallel to and as close as possible to the right-hand edge or curb, which is where she already was, and stop and remain standing until the authorized emergency vehicle had passed.
So you're saying if the lights were on, then that law would apply to control the plaintiff's behavior?
Exactly, precisely, Your Honor.
And so without that, then she didn't know what to do,
She was left with indecision.
This was an active scene, was it not?
Yes.
And there's evidence in the record that your client was aware of the type and the nature of the investigation that was taking place.
That's correct, Your Honor.
So it wasn't like your client was just an unknowing apartment complex tenant who got in their vehicle and had no idea what the deputy was doing there. I mean, she was aware why the deputy was there, the purpose why the deputy was there, and I venture to say that she was aware that the suspect, the alleged suspect, had gone into a vehicle and driven off.
Your Honor, she was there and she was aware of the circumstances that had produced the emergency call. There's nothing in the record as to whether she knew that the suspect had driven past her. We don't know whether she knew that or not.
But if she's aware of what created the emergency, then a reasonable person would think that if the deputy was not done with the scene investigation, that deputy was going to follow the suspect wherever he may have gone. And so that would involve the deputy moving her vehicle.
True, that's correct, Your Honor, but she was left with indecision as to exactly what the deputy was going to do. As she said, Deputy
Counsel.
Mason states in her affidavit that from the time she shifted into reverse until the time she moved was about a 3-second stop. And in her deposition, Ms. Holloway stated that she was watching, she saw the car, and she said when she pulled up and stopped, that's when she decided to go. So there was, when the police vehicle sat there for 3 seconds, she's left with indecision and wanted to leave a scene that had been getting violent.
Exactly, and under those circumstances, if you don't know what the police are doing, and as I believe I read somewhere in there, there had been a display of a firearm and an alleged domestic violence assault, wasn't the prudent thing to do to pause and wait and see what the officer was going to do next, especially if, as you say, people were spilling into the streets?
That would be one place that she could have proceeded, yes, Your Honor. But with all that was going on, the opposite side of that could be just as applicable, in that she's scared, she's got her family, she's got her children, she's already in the car with her lights on when the police vehicle pulls up. So she's ready to leave, and she saw her chance to get out of there, and that's what she did. And I don't believe that's an unreasonable way to proceed.
I would agree with you, except for that she veered around an active scene investigation involving a deputy who was still in her moving vehicle.
But the vehicle was stopped for 3 seconds. I think that's kind of, we're in a small window. In this particular case, we don't have a long pursuit that involves different intersections. We're in a very small window in this one. And it's involving quick decisions and what's reasonable at the time. And the one thing that would have put a stop to the whole thing would have been to turn on the emergency lights and turn the siren on. That would have, any indecision that was on the part of the plaintiff that was as to what to do at the time would have been cured by that. Or if at that point she had gone ahead and proceeded, then that would have erased any doubt as to her being wrong in her movement.
She was in a marked deputy. The deputy was in a marked unit, was she not?
Yes.
And the marked unit clearly displayed Harris County Sheriff's Office, and I'm assuming yellow around the white vehicle.
I'm not, excuse me, I'm not sure of all the markings.
Okay, but we know that they had a siren bar at the top, and it was probably displayed some sort of imagery that reflected that that was an official police officer vehicle.
Yes, yes.
Okay, so there's no confusion by Ms. Holloway that that car was in fact a deputy using, a uniformed deputy using a vehicle that was assigned to the Harris County Sheriff's Office for official business.
No, there was no confusion over that.
Okay.
So I can see how the emergency lights would have relevance if it's speeding down the highway and, you know, you're going down the highway and it's raining and there's a car on the side of the highway and he doesn't have his lights on so you don't see it. I don't, you know, something like that. But I still am just not seeing how, if she saw the reverse lights, how the emergency lights would have done something different. And is there evidence in the record, is that in her affidavit, that she would not have pulled behind the car if the lights had been on?
There's nothing to that effect, Your Honor, but she does state that she didn't see the reverse lights until she was being hit. So she saw her stop, she pulled forward, the car pulled back. This is all a matter of just split-second movements.
Which is the same amount of time the officer had to make the decision whether or not to pursue the suspect with an alleged firearm.
Well, we're not disagreeing that the officer acted in good faith in the decision to pursue. As the Amarillo court stated in Pruitt, there's two decisions to make: whether to act and then how to act. And the decision whether to act here was made in good faith. Our position is that the decision on how to act was not in good faith.
Which, there were several things listed in the brief, so there's the 3-point turn. Do you think that was, was that reasonable in good faith?
I think that's where the fine line gets most applicable, Your Honor, is that you have to, the case law says that you have to conduct, because these situations call for continuing assessment of the circumstances, because things change rapidly. And that's what happened here. And so the first turn of the 3-point turn was fine. It's the second turn where the problem is. And she needed to make a continuing assessment of the circumstances at the first turn, at the second turn, and then the third turn was not a part of the
Counsel,
argument.
just as you were saying that your client had to make some very fast decisions in that moment, wouldn't you agree that the deputy inside that vehicle had to make some very important decisions much more quickly than that?
She did, Your Honor, but the overriding decision to make was to abide by the statute and abide by the Harris County policy of, on a priority one pursuit, overhead lights and siren were required. And all she had to do was follow policy.
I assume she was going to, she just hadn't done it yet, because it was 1 second after the pursuit started.
She had every opportunity to do it. When she got back in her car, she got out of her car and had the people at the scene point out the suspect fleeing. She got back in her car and began the 3-point turn. At any point when she got back in her car, she could have turned the lights on. When she made the first turn, she could have turned the lights on. She could have done, when she shifted into reverse and before she started backing up, she could have turned the lights and the siren on. She had every opportunity to do that. It's a matter of I've never turned on the overhead lights and the siren in a law enforcement vehicle, but I suspect they don't require them to take a lot of time to do that. And so, excuse me, she could have done it at any point after she made the decision to pursue.
Is there evidence in the record that your client was there and saw the people signaling or communicating to the patrol deputy that the suspect was fleeing the scene?
No, Your Honor. There was no questioning and there was no answer that indicated that she saw him fleeing or saw anyone indicating that the suspect was leaving the scene.
Okay. Thank you.
If there's no more questions, we'll retire.
As you're ready, sir.
May it please the court. Texas officials, especially emergency responders, need to be able to do their jobs without constant fear of litigation for any mistake. This court should affirm the trial court's judgment for 2 reasons. First, Deputy Mason is entitled to the affirmative defense of official immunity. Second, Deputy Mason was responding to an emergency call and reacting to an emergency situation, acting in compliance with the laws and ordinances applicable to emergency actions, and was not reckless in doing so, and thus she is also entitled to the emergency exception. I'll begin with official immunity. Official immunity in Texas is an affirmative defense that comes from common law, and essentially it protects officers when they're performing discretionary duties in good faith for the governmental unit in the course and scope of those duties. There are two different standards, one for an emergency and one for a non-emergency situation. The emergency situation only applies in the context of a high-speed chase or other emergency law enforcement response that carries an inherent risk of harm to the public.
Including a 3-point turn in pursuit of an alleged suspect on a domestic violence call.
And Your Honor, I think under either standard, under the emergency or the non-emergency standard, we succeed on the official immunity. I don't know if the court needs to decide that here in this case, simply because we will go through this analysis as if it's an emergency. Essentially, on the emergency situation, whether the standard is that the county has to show whether a reasonably prudent officer under the same or similar circumstances could have believed that the need to immediately apprehend the suspect outweighed a clear risk of harm to the public in continuing to do so, and continuing to take whatever action that is. Here, the officer did consider, and let me be clear, that is an objective standard. It is not subjective. We look at it from what a reasonably prudent officer could have done, could have believed. And Deputy Mason is responding to an emergency, clearly. It's an assault family member. She gets a call that the caller's sister has been hit by her boyfriend, that there are guns out, that the fingers or the hand is on the trigger as that gun is being waved about. The officer is clearly responding to an emergency. As the officer is doing so, she has her lights and sirens on to get to the location, but she shuts them off as she's getting nearby because she knows that in domestic violence situations, people may end up running. And in fact, she hears over the radio, the suspect is possibly trying to leave, hears sirens in the background. As Deputy Mason also gets up, she shuts off the lights as well to make sure both the initial reason, but also to make sure that it's safer for her to see what's going on as well.
So she theoretically turned off the lights because she was afraid the suspect would see the lights and run.
Specifically the siren, but I think it's also applied with the lights.
Yeah.
As you get closer to the scene, and a suspect will see that and know that you're a police officer.
So officers are trained to turn off their lights for domestic violence.
Specifically sirens, but I believe the record reflects sirens, but lights
but that
also
is the training.
fits
That's
into
my
it.
question.
And that's actually reflected in 546.004, which are the exceptions to the requirements to use lights or sirens as you respond to these. Is when you have probable cause to believe that knowledge of the officer's location will cause a suspect to flee. And that's what we're dealing with here, is as officer
Can
or
you give us that section again? I'm sorry, I don't want to forget.
Texas Transportation Code 546.004. That is the exception to 546.003's requirement that an officer responding to an emergency use emergency equipment, the lights and sirens that we all know about. But Deputy Mason arrived on the scene and sees that there is clearly a situation. She knows that there are guns about. And there's a video that should be part of the record, and I'm not certain why it's...
So is somebody working on getting that to us?
Your Honor, actually, I communicated with my friend on the other side to make sure that we have an adequate copy, a correct copy under Texas Rule of Appellate Procedure 34.5E. We've agreed what is that copy. We were just waiting to see if we needed to take further action from the court, and then we will submit that.
We've issued an order that I believe is, the deadline is quickly approaching for us to receive that from the district clerk.
The district clerk was supposed to provide it by Monday. We made sure to communicate with the district clerk to ensure they were aware the order existed and that we are prepared to take whatever steps are needed to get the lost piece of the record into evidence, or into the record, excuse me.
Thanks to both of y'all for working on that.
Absolutely, Your Honor. So as long as an officer could have responded to that, it doesn't need to be every officer, considering the needs and risks of the situation, could have believed that the need was there and the risks were outweighed.
So, but I guess you're saying that the need was chasing this guy, but then, I mean, that doesn't mean it's like all bets are off at that point. You know what I mean?
Agreed, Your Honor. And that's why if we look at Deputy Mason's affidavit, she considered the situation. She looked at what needed to happen. She knows that it's a domestic violence call, somebody with a gun, and they've got their hand on the trigger. That's a dangerous situation. That is an emergency. And assault family members are one of the most heinous crimes that we have. It's somebody who could be hurt, killed. It may be anything. She doesn't know what she's responding to. And so just to hear that, she knows she needs to get there. And when you have somebody pointing out in the street, that's him, she considered everything, considered the setup of the roadway, the picture included in the record, the map on clerk's record at 95, shows how the roadway was set up. She had to make that three-point turn to be able to successfully follow the suspect.
Counsel, it was also policy that when she starts going, that she has the lights and sirens going, or is that covered in the exception that you gave us before?
So I think that that's an interesting interplay between the exception as well as Harris County Sheriff's Office policy. The policy is included at .109 to 114. And the officer responding to a priority 1 emergency is to use lights and sirens. But it also states that they're only supposed to run priority 1 as directed by dispatch unless a fresh pursuit. She has gotten to the location, the lights and sirens are off, and then the criminal suspect is driving past her. If the court looks at it as 2 separate instances, that could be considered a fresh pursuit where the priority 1 is ended and now she's taking another action. The court can also look at this as if priority 3, which is at 112 in the record, the clerk's record, it doesn't allow officers to invoke the exceptions. So it's really interesting with the policy, there's a level 0, 1, 2, and 3. 0 through 2 mention nothing about 546.004's exceptions. But priority 3 says an officer on a priority 3 call may not invoke the exceptions of 546.004, which implicitly means that an officer can invoke that. So since Deputy Mason knew that the criminal suspect may be fleeing, I believe she can invoke that 546.004, and I think the record supports that.
But you'd have to label the fresh pursuit as a priority call 1 or 3.
Or 2, because the officer was responding to a priority 1 call. The call slip reflects that. It also reflects that it got lowered to a priority 2. It was never a priority 3. Deputy Mason was responding to that emergency, was pursuing the criminal suspect who was fleeing, and she wasn't aware if there was a gun. As long as an officer could have taken those actions, she is entitled to official immunity.
Counsel, isn't it, after you assert your defense, isn't it incumbent on the other side to show that no reasonable police officer would have done this?
Yes, Justice Bridges.
Tell me the evidence in the record that supports their position.
So I don't believe there is any. And that's important because when the county meets its burden of showing official immunity, it goes to an elevated burden on the plaintiffs. And the elevated burden is that no reasonable officer could have taken those actions under the same or similar circumstances. And here that's not supported by any evidence. The court in Rodriguez and Sauls looked at everything and said that that didn't exist there. And what we're seeing instead is the testimony of Darla Holloway, her deposition testimony, and that testimony doesn't show that no reasonable officer could have done that. And while we have to look at the evidence in the light most favorable to the non-movement, it's important to note that we do not disregard necessary contextual evidence or evidence and inferences unfavorable to the non-movements if reasonable jurors could not. And as the court has pointed out as well in the record, this is the plaintiff's nephew who is the criminal suspect involved. The video of this will reflect that the people walking into the roadway actually walk in front of the plaintiff's vehicle. The video is important. Scott B. Harris says if the testimony versus the video controls if it shows clearly what happened, and that's what we see here.
So we focused today on the lights and the sirens and her not using those, which you say is justified under these things. But from the briefs, it seems like there were several things, such as, reversing at a faster speed, not looking behind her, things like that. Does your analysis change if we're looking at the risk versus the need of not looking behind her?
No, Your Honor, because just as the court pointed out and my friend on the other side said, all of this was a matter of split-second decisions. Deputy Mason analyzed the situation before starting her movement. As she started the movement, she went into that three-point turn believing everything was safe. She had no belief that anyone would drive past because people weren't driving around at that moment. She analyzed the situation, and 3 seconds after she finished that first part of the turn, she's in the reverse and she's backing up. That 3 seconds incorporates her putting the car into reverse, backing up, and the collision occurring. So 3 seconds is that fast. And we have to consider that these are split-second decisions.
And do courts piecemeal every behavior by a police officer, or is there a look at the totality of the circumstances and the actions that an officer takes when, responding to a high-speed chase or a fresh pursuit or responding to the scene?
And Your Honor, you're correct. The courts do look at this more holistically than anything. There are times that sometimes the analysis gets more spread out, where circumstances change, and originally it may not be there, but now it is. And those moments, but here we're dealing with 7 seconds and really almost 3 seconds in which the officer is trying to pursue, and the court should look at this holistically. And if I may move to the emergency exception to the Texas Tort Claims Act is actually a non-waiver of the county's immunity. Essentially, the Texas Tort Claims Act does not allow a plaintiff to sue when the officer is responding to an emergency call or reacting to an emergency situations when they're in compliance with the laws and ordinances applicable to emergency actions and not acting in reckless disregard or acting without caring about the safety of others. The court has said as long as the officer is not violating a law or ordinance, we look at it sort of under a collapsed recklessness standard. And in this instance, recklessness is not proven by negligence. And when we look at the cases that have come out in the past few years, there's City of Austin versus Powell. There is City of San Antonio versus Maspero. In both of those situations, there was alleged negligence. But negligence doesn't add up to recklessness. And my friend on the other side has stated if only she had just looked in her rearview mirror. Well, that's negligence. That's not recklessness. She wasn't in willful or wanton disregard for the safety of persons or property or conscious indifference while having subjective awareness of an extreme risk. At most, that was a momentary lapse of judgment that she didn't check that. And that is not one of the items that can take away the emergency exception. Here you have an officer who's responding to an emergency of an assault family member. There are weapons, there's fingers on triggers, there's a suspect fleeing. She is encountering an extreme situation in which she's got to make these split-second decisions.
Would your argument be any different if she had hit a person?
If she had hit a person, I think that would be different circumstances. But here she looked around and made sure it was safe. She did not hit a person because there wasn't a person there. She analyzed it and thought it was safe to do so. And under official immunity, we protect all but the plainly incompetent and those who knowingly violate the law. That's not what we have here. We have an officer who is trying to do the best job that she can, do it safely, and we want officers to be able to do that without fear of being sued and without years of litigation that ensue because of just an accidental lapse of judgment. Here, we do not have recklessness. The emergency exception is intact. We have an officer acting in good faith, and she's entitled to official immunity. And under both standards, we'd ask this court to affirm.
Rebuttal.
A couple of things. As to the split-second decisions, Your Honor, you still have to make, or Your Honors, you still have to make sound decisions. And Deputy Mason made the decision to proceed in violation of policy and statute in proceeding on a priority 1 pursuit without her lights and without her siren. And after making the first turn, the three-point turn, under the law, she had a duty to continue to reassess the circumstances. And if you're not going to have your lights on and your siren on, it is fundamental. In any situation, if you're backing out of your parking space at HEB or backing down your driveway into the street to go to work in the morning, it is fundamental. You look behind you before you back your car into the street or out into the lane.
So the county was saying that we consider it in a totality of the circumstances and all together, but you're really splitting it, like the first turn was okay, the second one wasn't. What's your authority for?
Well, I think in this situation, the decision in Saul's that said it needs to be a more holistic view of the totality of the circumstances, whether it is a de facto factor listing or whether it is the holistic approach. In this case, they merge, because what you have is the priority one pursuit that has started, but there is a long line of case law that says you have to, because of rapidly changing circumstances, you have to conduct an ongoing assessment of the circumstances. Well, the circumstances were one thing when she made the left turn because everything was in front of her, she could see it. She states that she knew that the plaintiff's vehicle was there. All she had to do was turn around and look. And that would, no reasonable, prudent police officer in the same circumstances would say it was good faith to not look behind you before you back your vehicle up into a crowded, active intersection like that.
Did she have a review camera, do we know?
There's nothing in the record
We'll
that
find
says
out.
that, but the thing is that she is supposed to address alternatives, and she addressed no alternatives in her affidavit.
So, counsel, I know you talked about the backing up without looking as being something that we fundamentally all do as part of responsibilities of driving a car. What I haven't heard you say yet is how you differentiate those acts as reckless as opposed to negligence.
It's the risk of harm to the people involved, Your Honor, at the if I may refer you to City of Houston versus Clark. The Supreme Court said requiring officers to assess alternatives ensures that public safety is not thrown to the wind in the heat of the chase. And I think that's what applies here, is that without assessing, well, what do I do? I'm not going to turn my lights on. I'm not going to give people a signal to pull over and sit at the curb and yield the right-of-way to me. What am I going to do? Well, it becomes reckless when she knows that there are vehicles that have been proceeding through this intersection, that this vehicle that she eventually runs into is sitting right there a car length away from her, and there are people spilling into the intersection, backing up without looking and just throwing your vehicle into reverse and going is a reckless endeavor.
Thank you.
Thank you.
Thank you.
All right, this case is submitted. Thank everybody for their time. Y'all have a good afternoon. All right.